What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we had more cross-examination of Shannon Burgess, the Commonwealth's witness, who may have some inaccuracies on his resume, but we get to redirect. And that's the question everybody had. How do you rehabilitate a witness like this whose credibility has been hammered away on cross? Does Alessi touch the data at the end of his cross? Does Brennan bring it up on redirect? Are we going to have recross and redirect? You betcha. Make sure you guys hit that like button. We're going to get to it now. So we jump back into cross right at the beginning of the day today, and Alessi points something out to make sure everybody understood that it's not just a Shannon Burgess problem and not just a Shannon Burgess question, but in fact, Hank Brennan is in on this. He knew about your educational problems and deficiencies and probably inaccuracies on your resume, CV, LinkedIn, whatever it may be. And he wants to make sure, Alessi wants to make sure the jury knows that Hank Brennan knew about this and purposely tried to hide it from the jury. That's at least what Alessi wants to present to them. And usually I think that stuff is kind of annoying and it's like, oh, what the lawyers do. And I don't like bringing in like, what did I tell you? But Hank Brennan does so much of that. And frankly, he does it again with this witness on redirect where he says, did I ever tell you to do something like this? On lots of witnesses, he's like, what did I ever ask you to do? Just tell the truth and let the data tell us what to do. Nobody told you to manipulate it in a certain way, et cetera, et cetera. He's done it so much. He's opened up the fact that he is involved in this case and is a player in this case, and therefore it's fair game. And we're going to listen to how Alessi just cracks it open today.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Morning, Mr. Burgess.
Morning.
On your direct examination yesterday, your experience was brought up in questions, correct?
Correct.
On your direct examination, your certifications were brought up in questions, correct?
Incorrect.
There was no discussion in your direct examination about having certifications in Celebrite and Magnet Forensic Axiom. Did I mishear you?
No, if I misheard your question, it was...
I asked about certifications. I'll repeat it, sir,
Sure.
in case I misspoke. On your direct exam.
The confidence in which he answers wrong is really something to me too. A couple times he's like incorrect. He's like, oh, I'm sorry, I misheard your question. The guy asks for a lot of grace on misunderstandings and misinterpretations for how he answers certain questions and speaks in court to me. Okay, like there was a lot of that with this witness.
Examination.
And how he talks about other people and how they mislead and how they screwed it up and they missed this and missed that and misunderstood this.
Your certifications were brought up in questions, correct?
yes, correct.
However, on your direct examination, no questions were asked of you at all about your supposed education, correct?
Correct.
And you did not bring up your educational background at all on
Correct.
direct examination, correct?
Correct.
A forensic examiner must prioritize.
Okay, then he gets into accuracy, reliability. Seconds are important. You testified so much yesterday to down to the second on the Lexus clock. That's so important. Lock that in. I thought he was going somewhere else. He ended up saying, okay, let's pull up the PowerPoint. And this is a good zinger. Okay, this is a good zinger, but I am going to get down to the fact that because yesterday I knew there was more cross coming. What's he going to do to the data? How is he going to tell us it's unreliable? How is he going to show and explain that it doesn't actually say what it looks like it said, right? So when he brings up the fact that seconds matter, seconds are so important, I was like, okay, good. Let's talk about where the seconds could be important in this timeline. Not really where he was going. He did have another zinger to really, embarrass this guy again, kick a guy while he's down. And let's listen to this, which again, I thought was very effective in cutting his credibility, but did it cut the credibility of the data?
Yes, according to the Lexus, yes.
According to the Lexus.
Yes.
In point of fact, Mr. Burgess, none of the 5 timelines that we just reviewed from your presentation are accurate at all, and certainly not down to the second. Am I right or am I wrong?
So I kind of started in the middle of that question, but he was basically showing him all his timelines, and he's like, they're not right. Not down to even the second. They're just completely wrong, aren't they?
You are wrong.
Are you?
And again, he confidently says Mr. Alessi's wrong while he's wrong again on the stand, which is just not good. But he hasn't picked up on what Alessi's doing yet.
Am I right or am I wrong?
You are wrong.
Are you aware? And if we could go back to the first slide, which is slide 32, and we'll look at each of them quickly.
Sure.
Are you aware that all of the relevant events in the timeline you described in your presentation in these slides actually occurred on January 29th, 2022, not January 30th, 2022? Do you know that?
Did you order the code red? I can imagine Alessi, screaming that. He's like, in fact, these happened on January 29th. He had the wrong day. He put January 30th very clearly in his report. This all happened on January 29th. Alessi got him. It's all wrong. His whole report is wrong. Let's keep listening, and then I will give you my thoughts on how a jury could view something like this.
This is January 30th, 2022.
That's
January 29th, correct.
It's January 29th, 2022. And in terms of January 30th, I want to go back and make sure it's very, very clear. In your presentation, they actually occurred on January 29th, 2022, correct?
The night of the incident, yes.
Can I have a moment, Your Honor, please?
Yes.
Thank you.
He very clearly does not know this answer, and Alessi does. He's like still confused as he is sitting there right in this moment on whether it was January 29th or 30th. To me, he's probably sweating through his shirt trying to figure out, did I screw this up? Now, there's an important aspect to this, so stick with me here on it.
Mr. Burgess, once that timeline crosses into midnight, it's January 30th, not January 29th, correct?
Correct. Yes, it is January 30th. Yes.
Meaning the timeline is showing January 30th.
So in actuality, these 5 timelines, as you testified to them yesterday, are not accurate down to the second, correct? Because you got the wrong date.
Well, parlance, yes, but yes, they are still accurate to the second.
But the date,
Parlance? It's more than parlance, brother.
these 5 timelines, let's pursue this. These 5 timelines are exactly 24 hours off from the time where the event actually occurred, correct?
No. So these events occurred on January 30th. If I misspoke and said the 29th, yes.
Okay. You understand my point?
Yes, I do.
See, I think he still thinks it's the 30th. I think he still thinks it's wrong. I think Alessi thinks he admitted that he screwed it up and it's on the 29th. So it was kind of a little bit clunky there, but got the point across. Timelines are 24 hours off. Okay. I'm going to answer some questions. Then I really want to get to a point here. Drea, question. Didn't he say he never testified in federal court? I think he said that. I can't remember, so don't hold me to it. But just because that CV that we're going to talk about later was filed in federal court does not mean he actually testified in federal court, if that was the question. Could Alessi have asked SB when he actually last enrolled at UAB and how many units he had left? Otherwise, it's disingenuous for him to say an expected date if he was never enrolled to begin with. Yeah, you just don't know the answer. Like, what if he's 1 credit short or something like that? And it could make all this less damning. If you don't know the answer, sometimes you don't want to wade in those waters as a lawyer. Why was the wrong date not a bigger deal? SB testified his times are from January 30th. Shouldn't that make them irrelevant to the death of John O'Keefe on January 29th? So let me answer this question. I think that there are going to be jurors on this jury, and I'm going to mention this multiple times throughout today specifically and what happened in court today. There are going to be jurors that view this one of 2 ways, okay? And one way that they're going to view this data is, if you want to just simplify it down, you feel bad for the guy, secondhand embarrassment, get the man off the stand. We realize, maybe he wasn't honest about his education, but the data is the data, and he's just basically reading it to us. And guess what? It sure sounds like Karen Reed did a 3-point turn, on whatever that other road is, comes to Fairview. A few minutes later, her car backs up. And that time-ish, within a minute, no big deal, up or down 21 to 29 seconds. There's variance. He kind of explained that to us. At the same time-ish, John O'Keefe's phone has the last human interaction. There will, in my opinion, be at least one juror, probably multiple jurors, who want to simplify it down, who want to believe an expert like this, and that's how they'll see it. Unless Alessi can get them to believe otherwise, which we're going to listen through his cross. Now, if a juror has that mindset and they're willing to dismiss the credibility issues and the education issues, and we'll talk about how Hank Brennan deals with that on redirect, they're probably willing to also look past the fact that he put the wrong date on there, that this 24-hour problem is not going to dissuade them. And they're going to be like, he meant the 29th. Even Alessi agrees it's exactly 24 hours. So if we put it on the 29th, it matches up with John O'Keefe's movement and his phone interaction and things like that. I've seen jurors do it in trials before. It really wouldn't be that surprising. And if you start going through that, down that road, was this actually a good witness for the Commonwealth? Let me know. There are also jurors that are going to say, I don't care if this timeline lines up to the second. There's somebody put on my Twitter, I don't care if they show me a video of Karen Reed hitting John O'Keefe with a car. I still wouldn't believe it. There are going to be jurors that are starting to get in that camp with how bad this witness was, how much the credibility was crushed, and how many mistakes were in his report that he's like, I'm sorry, sir, you seem like a nice man. There are way too many inaccuracies in your CV, in your report, in your time variance, in your date variance. I just can't believe a word you testified to. In my opinion, there are multiple jurors also in that camp at this point. Brian B said, I'm worried about the cyberbullying of this guy. People's sad story sometimes begins with cyberbullying. Yes, he did something wrong, still human. I agree 100%. Like, I do not want to bash this guy personally. Everything I say is specifically to take his credibility on the stand and how I would think about it. I would have a very difficult time taking much of what he said to be impactful to me. But I could understand with some of the other witnesses how the data is starting to line up. Now, there are still some major issues for the Commonwealth with the data, right? And we've heard a lot about 1241 or 1242 when Karen Reed went into John O'Keefe's house, or when the Lexus turned off, or when the voicemail was left. But we've got that pesky 1236 time from Trooper Garino that her phone connected to O'Keefe's Wi-Fi, and I think he said it could have connected in the driveway. So in the driveway is not like 5 minutes away, right? So 1236, if her phone connects, even with this timeline, still major reasonable doubt problems that the Commonwealth has to get to. And I'll tell you what this witness, I don't believe, convinced a single juror of, that a car hit John O'Keefe, which is an ultimate issue in this case that they have to prove. And I don't care how credible or not credible this witness is, or how much you trust the data, it did not prove a collision occurred, but the Commonwealth still has the ball, and they're still proving their case. Okay, let's keep going on what Alessi tries to get at here with this cross. He gets into the inconsistencies, which are really important, between when he says that things happen, when Whiffen says things happen, when Garino says things happen. He didn't get into, but in my mind, I'm also thinking there's an issue with what Jen McCabe says she saw and when she saw it. There's an issue with Ryan Nagel. Did he see this three-point turn? Did it happen right before he did? Did he see the backup event? Did he see John O'Keefe get out of the car? Did he see any of the steps John O'Keefe took? There are inconsistencies with what the data says and what their own eyewitnesses testified to. That's an issue they're going to have to deal with. He talks about the pocket state stuff and what he does know, what he doesn't know about that. He talks about, do you know what Welcher's trying to prove? And he says, no. It's like, really? You don't realize he's trying to prove a collision occurred? Then he kind of said, yes, there's a sidebar, and unless he changes gears, because he can't testify to what Welcher knows, but he even says he's been an accident reconstructionist in other cases. So I don't know. It seemed a little slimy there. Not slimy, but evasive, I should say. Burgess says DeSogra, or whatever the defense expert name is, got it wrong in his attempt to adjust the timestamps. Alessi keeps saying that he demonstrates the lock event happened after the collision. Burgess says, you're saying that, but it's incorrect because he did it incorrectly. So obviously, if after the impact happens and the Emmy and other people are going to testify to, it was incapacitating. If John O'Keefe kept using his phone, that's an issue for the Commonwealth, obviously. So we'll see. And then he starts talking about, Mr. Burgess, you need the data to line up a certain way because you agree that if John O'Keefe was using his phone after impact, that's a problem for you. And we'll listen to how Burgess deals with that. Because this is where, again, Alessi is not saying the data is wrong. And I don't think he needs to say the data is wrong. And that's what everybody's asking about. And, I kind of opened up this video is Alessi going to attack the data? Is he going to prove the data is wrong? I don't really think he did. I don't really think he can. But I also don't really think he needs to as the defense's theory of the case. And what I mean by that is the data can be right. And if you can prove John O'Keefe kept walking and kept using his phone after the backup event, which he got this witness to admit, every triggering event or text stream event, whatever verbiage you want, whatever parlance you want to use, if John O'Keefe kept using his phone, maybe Karen Reed just backed up and then left and went home. Maybe she backed up to try to say something to John O'Keefe, but he was already inside. Whatever. Jurors' minds will run wild on what they think could happen. Maybe John O'Keefe walked in the house, dropped his phone on the counter because he didn't want to talk to Karen Reed the rest of the night, hung out with his buddies. I don't know. They'll start to think of all sorts of things. I don't really care to do that myself. What I care to do is what are they actually proving? And I think if John O'Keefe is walking and using his phone after Karen Reed backs up, that crushes the Commonwealth's timeline. And I think Alessi would rather say that's what the data shows, not that the data is wrong. And additionally, 132 and change might be better for the defense's timeline than 131 and change if we're talking about that 136 time that I think the defense is going to hammer on. So let's see how Burgess deals with some of this.
30th report, and this is a question, is the reason you failed to take that final analytical final analytic step we've been talking about in your January 30 report was because you knew if you did that if you calculated the actual time of the 11:62 text stream event based upon your own methodological analysis of the clock skew, there would always be continued interaction on Mr. O'Keefe's phone after the text stream event.
No.
So you deny that?
Yes.
Did you keep your January 30, 2025 report purposefully vague by merely noting a clock skew without engaging in any further analysis, such as tethering that clock skew or otherwise connecting it to the text stream event in Dr. Welcher's slide presentation?
No, I did not.
So he says no. I liked that question because I kind of think the Commonwealth, all the way back to Lally, has kept this kind of vague and has not told us exactly when anything has happened. And even when they have, they've been shifty and they've left it open for time variance. And again, some jurors, I promise you, they're just not going to care about that. They're going to be like 12:31, 12:32. What's the difference? He used his phone at 12:32, 06 or 16. What's the difference? 10 seconds up or down, big deal. 24 hours off, he meant the 29th. I'm telling you, I've had jurors tell me stuff like that, and I'm just like, oh. But that's what happens sometimes. Chris K said, no rehabilitation for this witness. In my opinion, the expert lost all credibility. If you deal in details but can't handle simple proofreading, not good. I'm a little surprised to hear this because Chris is somebody that I would think, just because we've gotten to know each other with his comments and DMs and stuff like that, that he would give people grace and have some empathy for this guy and feel bad for him. But I think Chris is speaking specifically professionally for this guy. And if he was a juror looking at this guy as a professional expert, he doesn't think he's a bad person, but he just can't take his testimony at face value because he's lost credibility in the work he's performed.
Switch to another topic.
All right, we're going to jump ahead to this other topic about how after looking at everybody else's work, he decided to clarify what's in his report. And this is kind of what we talked about. We would focus on Cross big time, the timing of how he did everything. But Brennan also had a comeback to this on redirect that we'll get to.
Adjusted timestamps, yes.
Let me ask my question again, and if it's not clear, please let me know.
Sure.
After reviewing what we've discussed, prepared by Dr. Welcher, Mr. DeSoger, and Ian Whiffen, each and all of which established that the 1162.2 text stream event occurred before the last user activity on Mr. O'Keefe's phone, you then decided to issue a new report that would become dated May 8th, 2025. Is that statement I just made correct?
Yes, that is correct.
Now let's take a look at your May 8th, 2025 report. You departed in your May 8th, 2000. Sir, do you have that report in
I
front
do,
of you?
yes.
Do you need a moment to look at it, or are you ready to take
No,
questions?
go ahead.
Thank you. You departed from your analysis. Let's start it this way. In this May 8th, 2025 report, you departed from your analysis in your January 2025 report to reach a conclusion that would attempt to put the 1162.2 text stream event after human interaction with Mr. O'Keefe's phone, correct?
No, I did not depart from my original report. I clarified.
Okay, so you didn't depart from it, but you, in your May 8th report, but your position is you clarified it.
Correct.
But isn't it correct?
Departed, clarified, changed. If you're a juror, what do you think about this? And again, some of this I think jurors could think is, nitpicky. Does it really matter? The data's the data. The timeline's good. But you're not necessarily always focused on that. Okay, that would be like me trying to convince people that come on here and just want to hate and go crazy and yell. And it's like, well, I want to try to convince them. I really want them to see it my way. Usually as a lawyer, you want the jurors entrenched with you to be more and more entrenched. So it's like if you have some jurors that are hating this guy's credibility and thinking that I just can't believe him, I can't trust him, you want to give him more and more reason to dismiss everything he has to say and everything he has touched, because that's going to affect other witnesses as well. And so that's what a lot of this does.
That in your January 30, 2025 report, you did not address at all whether the 1162.2 text stream event occurred before or after the last user event on Mr. O'Keefe's phone, correct?
Correct.
But you did that in your May 8th report, correct?
Correct.
You don't call that a change, sir?
No, sir, I do not.
You call that a clarification.
I do.
Definitely a difference. Whatever word you want to use is definitely something different happening. Then he goes, as stated in initial report, where did you say that? He's like, well, I said it here, but different words. Again, a little semantic-y, kind of going both ways from Alessi and from the witness. Alessi says he thinks Burgess exhibited classic confirmation bias. And then again, now he's getting back to the data and why it's so important. Again, the data doesn't have to be wrong, but why you made sure the data said what it said and what you decided to focus on, because Burgess accuses the defense expert of doing the same exact thing, focusing and twisting and misrepresenting times to say what you wanted to say. He's like, well, you did the same thing, Burgess. You focused on something specifically because that's the only way it works. And if you end up being wrong, the Commonwealth's theory is blown.
Believe that is not confirmation bias.
No.
Choosing the 3-point turn as the independent data source is the only way you could ever get the text stream event to even possibly occur after the lock event on Mr. O'Keefe's phone, correct?
That adjustment is the only adjustment that can be applied due to the data. Yes.
And that adjustment is the only thing that can be done to get the text stream event 1162.2 to occur after the lock on Mr. O'Keefe's phone, correct?
Correct.
And that only one is the one that you chose, correct?
Correct.
And that's only because it's not a pinpoint in time. It's an amorphous range that can only, in your words, be approximated, correct?
No, that is because it is the only time adjustment in that time range that can be applied.
So
It can be applied. And he's going to really get into this on redirect because Brendan is going to use this as like proof he picked the best and most accurate times to create the timeline and create the data. Nicole said, Rob from Law and Lumber said, witness stated out of all the Lexus interactions available to use as a constant, he chose the only one that would make 1162 happen near iPhone lock. the only one. So when you use words like near at this specific, I'll say this specific time, because near, some people may think a bunch of them would have made it near, but not exactly like how it worked here. But regardless, he says his big thing is you pick the triggering event closest to the incident you want to get the time. And he said something like a triggering event at 1 o'clock is not going to be as good as a triggering event at 2 o'clock if you're trying to figure out what happened at 3 o'clock. It's like, really? We're going to listen to some of that. But jurors are going to have to determine what they believe and what they don't. There was another one I wanted to read here. Mickey, I'm for Karen, but I do try to listen to all. I knew this witness was lost on me when halfway through redirect, I realized I hadn't heard nor paid attention to anything, having to go back often. And this is another thing, Mickey, that people watching this right now, the people that are in the chat that are fully invested in this case, and they watch the stream all day with somebody, they come and watch a recap, they watch another recap after this. The jurors are listening to this once, and they're having days where their kids are sick, they don't feel good, they've got something, they saw a work email at night that they're stressed about, they get tired, they get hungry. How much are they picking up? Are they picking up everything? Are they missing things that are important? That's interesting. And Mountaineer Mama says she doesn't even think this will be important to a lot of the jurors. Like, they just be like, no, it's too confusing.
It's your view that that's the only one that can be applied, but it is in, even what you're using is, in your words, an approximate time, correct?
Correct.
Isn't the shortcoming, sir, in your analysis that you ignored the additional user activity on Mr. O'Keefe's device that occurred after the lock event? Yes, I can.
He means the pocket, was it taken out of the pocket, things like that.
Isn't the shortcoming in your analysis, sir, that your analysis ignores the additional user activity on John O'Keefe's device, his cell phone, that occurred after the lock event?
No.
Well, let's take a look at events that, you tell me if I'm correct or not, occur after the text stream event 1162.2.
Sure.
So do you recall our discussion yesterday about the Apple Health data event of 36 steps covering a distance of over 84 feet? Do you recall that?
Yes, I do.
And do you recall that that occurred at 12:32:16?
Yes, I do.
And that's after the text stream event of
Correct.
Dr. Welcher that he put in his slide, correct?
Correct.
Do you also recall a Doppler pocket state detection at 12:33:14? Do you recall that?
Yes, I do.
And that is almost an entire minute after the 1162.2 text stream event that is identified by your colleague, the licensed engineer, Dr. Welcher, in his slide presentation, correct?
Correct. And
Your colleague, the licensed engineer.
neither one of those are user interaction.
I understand your,
And he says neither are user interaction. Interesting. I think minds could differ on that. Again, where's the jury leaning? What are they thinking? How do they feel about that statement?
well, but let's just take one of them.
Sure.
And that is the Apple Health data event of 36 steps covering a distance of 84 feet at 12:32:16. Would you agree that those steps covering that distance is human activity, at least? Would you agree that's human activity?
Yes.
Thank you. Let's take a look at opinion number.
So he agrees that the steps are human activity. That's interesting. Then they get back to his report. They talk about the offset of -3 seconds for the infotainment. Now, there's not a lot of discussion on that in his first report. They ask, where did you get the term collision? He said from the MSP crash reports. He's like, you didn't list them anywhere on your May 8th report, did you? He goes, yes, I did. He's like, where? He goes, well, I listed them on my first report. And unless he's like, but you didn't on the May 8th report. That felt like, one reach too far. It's like if it's a supplemental report or you supplemented your report and you already listed that you read the crash reports, you probably don't need to say that you listed them again. That's just me, the way I look at it. I felt like that was something, if I wanted to get, think unless he was just kind of nitpicking on stuff that didn't matter, that would probably be one. Every tech stream event does not mean a collision. I thought that was really good. 30 tech stream events in 8 months. I thought that was really important and really good. And again, I think a lot of this is foundationally building on what the defense is going to do with their experts. Trigger or tech stream event never proves a collision on its own. And that's important based on Alan Jackson's opening statement where he said they will never prove a collision. So these tech stream events or whatever you want to call these triggering events, they do not prove a collision happened. And still nothing the Commonwealth has done proved a collision happened. Like I said already, they have the ball. They're still running the ball, and we'll see how it goes. He talks about criticizing Miss Gaffney. Alessi's like, she didn't have the same updated software you did. And that's kind of where he ended his cross, which I did not expect it to end there. I thought it would be better. I thought he would have a stronger ending based on how strong some of the points were throughout. Before we get to redirect, let's answer a couple questions. Cool Mom Vibes. What notes is the judge taking? Every judge does a little bit differently. Some take notes with every single witness. Some take notes on objections. Some take notes on witnesses. Some take notes on what the lawyers do. Every judge does a little bit differently. Will the defendant be able to explain to the jury the rules of the CJS explicitly requires P to provide D with their experts' conclusions before trial starts? No, they're not going to say, here's the rules of discovery. This is an undisclosed or late disclosed expert report. The damage that he did saying you did this in the middle of trial, knowing when trial started with that timeline, that's the best they're going to get. I think Hank Brennan is devious because he's a DA and this is his side hustle. No, I don't. Hard to believe a prosecutor would be this obviously underhanded. Yeah, I think that this was just a horrible move, bad move, risk reward, not thought of appropriately, in my opinion. I've been struggling to remain unbiased because I've watched the first trial. Any advice on how to remain open-minded? Honestly, Caitlin Gibson, don't make yourself crazy over this. Just is what it is, right? You're a human being. It's impossible to probably get rid of the bias you have at this point. Here's what I would say. Try to think about it from the other side. Could a juror see it this way? You're probably not going to, and that's okay. You can still watch, partake in the chat, discuss this, tell us how you see it. But just try to think, what do I think a juror that would disagree with me would say? I think that's probably the best some people are going to be able to do. Defense thinks that definitely think the defense should really rely on the medical, no evidence of a crash by triple board certified ME and better than Burgess confusing AF data. Yeah, I mean, that's what I'm saying. You don't have to fight the data, right? You have to fight certain things and why you're picking and choosing certain things and what the data could show, but you don't have to fight the data. And I think that's a misnomer from a bunch of people saying, whoa, he didn't talk about the data. Even Hank Brennan brings it up on redirect. He didn't talk about the data, but he did. He just talked about how maybe it doesn't show what you say it shows. Figuring out how to use the chat. Can we get the LYK merch that asks, what is your preferred parlance? I do like that. That is good. Okay, let's get to the redirect here. And he talks about the sequestration orders. You know what it is. You didn't violate it. I didn't share anything with you. He's going to kind of compare that with ARCA. I wasn't telling you what other people were saying. And when ARCA's up there, he's going to be like, people were telling you what was being said in the first trial or in the first proceedings. But then we get to how is he going to rehabilitate the LinkedIn account, the educational credibility of this witness on a scale of 1 to 10. As we listen to this, let me know how well you think Brennan rehabilitated this witness's credibility issues.
Give your opinions and you've testified. Do you have any information and knowledge about this trial as it actually occurred until the point when you testified?
No, I do not.
You were asked some questions about your CV. A CV is a resume?
Yes, it is.
Okay. And you were asked about a LinkedIn account.
Yes, I was.
Is your LinkedIn account different than your CV?
Yes, it is.
And in this case, when did you learn that your LinkedIn account was wrong or had not been updated? When was the first time you learned that?
That was yesterday.
When you started your LinkedIn account, do you remember when it was you set it up?
I do not. It would have been maybe 10 years ago or more.
Do you routinely update your LinkedIn account?
No, I do not.
When you set up your LinkedIn account, the section where it asks for education, whether graduated or ongoing, do you remember filling out that section?
I don't particularly remember filling it out, but obviously I did at some point.
When you...
Brennan has some tells, and he kind of freezes when it's an answer he doesn't like. And he's like, I mean, do you even remember doing that? He's like, Well, no, he thought he was just going to say no and he was going to move on. He's like, no, but I obviously did at some point.
We're asked about Aperture's website. How many experts are associated with Aperture?
I could give you a rough number between 80 and 100,
How many offices?
15 or so.
Are you involved in the website design or content?
No, I'm not.
Do you know if Aperture
You're not, but like, who in the chat has given their resume or bio for anything ever? You are always the one that drafts it, tells them where to find it, updates it when it's needed. Everybody's resume is out of date, right? It's one thing to be like, I am on, I'll just do it for mine. I bet you on some website somewhere it says I'm on the Florida Civil Rules Committee because I did my multiple terms and then you term off. So right now I am not on it. I'm going to be on a different committee next time around. So somewhere it probably says I'm on the committee. And if somebody pulled that up and was like, oh, you're not on the committee, I'd be like, oh no, I didn't update that one. I was on the committee from, whatever, 2000, I don't even know, 18 to 2024, something like that. And that's an easy explanation because I was actually on the committee. I actually did do that. It was actually true at some point. To say you graduated in 2018 or 2024 or whatever date, that was always false whenever you prepared it and you admitted preparing it. The problem with part of this rehabilitation is, the problem for Hank Brennan is, people know what LinkedIn is. People have made their resumes. Some people have even taken classes on how to make a resume. And like 101 is, don't lie on your resume. Don't put something on there you haven't done. And it's not only the wrong date, it's a major that doesn't exist. That's so much more than just what he's trying to do here.
gets the information from their website directly from LinkedIn?
I don't know where they get all of their information from.
Did you ever weigh in or develop your information that was on Aperture's website?
No, not on the website.
You do.
That's just not true. He had to at some point give them something that they use to make on the website. He had to. Even if it's his resume when he interviewed, did they take it from that? He had a hand in what they put on the website. I don't understand how it could be otherwise.
Provide CVs before you come to court, don't you?
Yes, I do.
And in this case, you were asked by the defense, when you provide your CV, do you understand that it's going to be reviewed by whoever requests it, the Commonwealth or the defense,
Yes, I do.
and that it will be shared with both sides in the court?
Yes.
In fact, the first time you provided a CV in this case, was it October 11, 2014?
Objection, Your Honor.
So the leading nature sustained.
Do you remember the first?
She says leading nature, okay? And we're at the 3:11 mark. But we're going to watch about 8 more minutes of this. Count how many times Hank Brennan has the answer to his question contained in his question, effectively giving this witness the answer he wants, which is inappropriate on redirect. Hank Brennan's a defense attorney, probably more used to crossing witnesses. You're allowed to do that on cross-examination. He does it so much here. It annoyed me, probably annoyed me a lot more than it annoys any juror. So I have to take that into account and realize it's bothering me more than it's bothering them. It's usually pretty effective, right? It's usually pretty effective when you can give your witness the answers you want. And so let's just watch here. Eventually, Alessi's like, I got to have a sidebar, Judge. We got to talk about this.
First time you provided a CV in this case?
It would have been around October
What year?
2024, sorry.
And when you provided that, was it as an exhibit to something?
Yes, if I recall, it was as an exhibit to the initial protocol that I sent out.
And when you submitted that CV, did you appreciate whether or not it would be part of a court filing in public?
Yes, I did.
If I could have exhibit 183, please.
Nicole, I agree. Having the data that shows a backup event at 12:31/12:32 and his phone being done moving forever at 12:32, I think that's a good timeline the Commonwealth can work with. I think those data points, if the jury believes them, this witness could have been really effective. That's why it really sucks for the Commonwealth that this guy has the worst educational credibility I've ever seen from an expert witness testifying in a trial ever. Whether I've tried the case myself, worked on the case, or watched the case on YouTube. Never have I seen that bad of a beating on your educational credibility. Now, I also think there are some things that are bad for the Commonwealth in the same exact timeline that the data provides, which is why you still have to prove he was hit by a car. No matter how perfect the timeline lines up, you have to prove he was hit by a car. And you also have to figure out that, again, that pesky 1236 connecting to the Wi-Fi just doesn't seem to add up.
183. You could enlarge the top section. Right there is good. And sir, when you provided this CV to be filed with the court and made public, did you indicate that you had obtained a bachelor degree?
No, I did not.
Why did you put currently pursuing?
Because I am currently pursuing a bachelor's degree.
And did you understand your CV was received by the defense and they knew this?
Yes, I do understand that.
Subsequently, you were asked to provide an updated CV in April 2025.
Yes, I was.
Did you do that?
I did.
Can we have Exhibit 184?
So I saw a bunch of people saying, haha, see, Peter, you were wrong. He didn't misrepresent anything. He didn't lie about anything. He didn't put any falsified information in here. He gave a correct CV to the Commonwealth. If you watch the defense's cross, they never said you gave a CV to the Commonwealth that was wrong. They said you at some point created a CV, created a LinkedIn page, wrong information that was not true. Still more to come on that on recross. But that's what they said. And that is still a big deal. To say that's not a big deal, it's like, I want to live in your world where it's like nothing matters. Actually, I don't. I don't actually want to live in that world at all. Truth has to matter. Reality has to matter. Honesty and integrity have to matter.
Did you further appreciate this would be provided to both the court and the defense?
Yes, I did.
Did you represent to the defense that your education included earning a bachelor degree?
No, I did not.
You've testified in, you can take that down, please. You've testified in many other cases
I have. Yes.
in courts around the country.
Yes, I have.
And when you've testified in other courts around the country, do you know whether there are transcripts of your actual testimony?
Yes, I believe there are.
Have you ever represented in
So, Mark, here's where it goes. I put your question up because I knew this question was coming. Have you ever represented to another court that you have a bachelor's degree?
any court of your actual testimony?
Yes, I believe there are.
Have you ever represented in any court that you achieved your bachelor's degree?
No, I have not.
Have you ever inflated your qualifications in a court?
No, I have not.
When I asked you about some of your background, you told us that you had certificates in celibate.
Evelyn, I agree. I think that's great. And I think if he just never put that on his resume and just put his AA, it would have been fine. And Hank Brennan gets to that. It's like, brother, nobody was arguing you can't be an expert with an AA. Nobody's arguing that. What we're arguing is don't put you have a bachelor's degree if you don't.
Celebrate and Axiom. I didn't go through all of the qualifications and all the accomplishments you had, did I?
No, you did not.
Do you have professional certifications, GIAC, Advanced Smartphone Forensic Analysis?
Yes, I do.
Do you have professional certification from CCME, Cellbrite Certified Mobile Examiner?
Objection, Your Honor. Sustained.
Do you have professional certifications as a Magnet Certified Forensic Examiner?
Objection, Your Honor. Sustained.
All of these are leading questions.
Sustained for the same reason.
I'm sorry?
Sustained for the same reason.
Do you have a number of certificates that I did not ask you about?
Yes, you do.
Was there a trigger recorded when Karen Reed hit John O'Keefe's truck? It's a good question. They didn't talk about that. I don't know. Honestly, like the brain is kind of turning to mush when it comes to these triggering events and timelines because of all that's going on. Commonwealth needs to make sure it's streamlined and easy for the jury to follow.
Can you share some of those with us?
Sure. So one of those is going to be GIAC, Advanced Smartphone Forensics. So that's going to be Global Information Assurance certification. And that is basically a 40-hour class or 48-hour class with a test at the end to get that certification. There's also a Cellbrite Certified Mobile Examiner certification. That is specifically to, kind of demonstrate your knowledge of the Cellbrite software, as well as Magnet Forensics certifications, again, for their software.
Brennan is trying to be like, oh, I didn't intentionally not talk about the education. Look at all this other stuff I didn't ask you about. You have all these certifications, all this continuing education. There's just too much to go through in your resume. That's why we didn't get to the education.
Specifically.
Any certifications regarding computer hacking?
What was that last part? Sorry.
Any certifications regarding computer hacking?
No, not currently.
Okay. Did you also take any classes regarding crash data or BOSH?
Yes, I have.
What do you have for certificates in that arena?
So those certifications would be Crash Data Retrieval Technician and Crash Data Retrieval Analyst. So those courses would be around acquiring and analyzing crash data from airbag control modules.
You mentioned that you had over 700 hours
Yes, I do.
of classes and certification.
Yes, that's of classes and classes and seminars or conferences, specifically in digital forensics or vehicle forensics.
Do you need a bachelor's degree to be competent and achieve in this area?
No, I do not.
Is a
Yeah, nobody said you did, but watch where Hank Brennan goes with this.
bachelor's degree a prerequisite of success in a particular field?
No, it is not.
You ever hear of Bill Gates,
Yes.
Stephen Jobs,
Yes.
Oprah Winfrey?
Sustained.
So somebody sent me a thing that said Oprah Winfrey actually has her bachelor's degree, which is funny. But I would have followed that up if I was Leslie, be like, hey, you aware if Steve Jobs or Bill Gates or Oprah Winfrey ever said they did have a bachelor's degree when they actually didn't, or that they had it from a university that they didn't, or that they had it in a field that didn't actually exist? Did that ever happen with those people? Are you comparing yourself to Bill Gates, sir? You think Bill Gates would have made these mistakes? I would have driven a truck through what Hank Brennan was going on there, because nobody was saying that. Nobody was saying that.
You had become engaged in this case in October 2024.
Correct.
And when you first became engaged, you had a chance to look at photographs and some data.
Yes, I did.
At that point, you hadn't had a chance. Did you have had you had a chance to actually inspect any of the physical property?
No, I had not.
Did you have an understanding that somebody else did?
Yes, I did.
Who?
Miss Gaffney and a number of other people with the MSP.
Attended some type of procedure?
Correct.
And do you know who led the actual procedure?
As far as I'm aware, it would have been Miss Gaffney.
The defense expert?
Correct.
You filed a protocol. What was the purpose in October when you first got involved in filing a protocol?
Sure. So the first purpose of the protocol was just to address the fact that we were missing data that we expected, and address a potential solution to gather more data.
Without having looked at the physical property, the actual boards, how did you conclude simply on data and photographs that there was missing data?
Sure. So that would be reviewing the initial data that was provided, and not seeing user data like I would expect. And that's because there's a number of different chips that are on a circuit board for an infotainment or a telematics or any other module. And there's a number of different data bearing chips. The purpose of those chips will vary. Some chips' main purpose is to store user data. Some chips' main purpose is to store software or firmware. So if you're gathering, acquiring data from chips that only have software and firmware, then you would not expect, or you would not see user data within those chips.
When you made that analysis and concluded that there was missing data, had there been any report provided by Ms. Gaffney suggesting there was missing data?
No, there was not.
Had there been any analysis
So this is Brennan again leading him down the way of, you actually were not corrected by them, right?
or opinion alerting that there was missing data?
No, there was not.
Was there anything to indicate that the person who did this test missed data at that point?
No, not at that point.
When you decided to write a protocol so you could actually look at the boards and do an analysis, did you put that protocol in writing?
Yes, I did.
And do you remember if that was around October 10th, 2024?
That sounds familiar. Yes.
Now, when you were cross-examined, the attorney asked you if you knew what the word mendacity meant. Do you remember that?
Yes, I do.
And you didn't know. Do you now know that means to lie or be untruthful?
Sustained.
He didn't ask you a question. He just asked you if you knew what the word was. Remember that?
Yes, I do.
Do you remember he also, on cross-examination, suggested that when you had your mistake about megabytes, megabits, it was the defense expert that alerted you to that mistake? Do you remember that suggestion by the defense?
Yes, I do.
Did they ever show you the documents so you could see the chronology?
No, they did not.
You wrote a report on October 10th, 2024.
And he goes through, and his report was before the defenses. So I thought that was a good point by Hank Brennan to at least, show that maybe Alessi was making him look bad in ways that he didn't even look bad. How effective was it? I don't know. They talk about his concerns with DeSorga's report, and we're going to get to those in a little bit. The impact time and the last movement didn't affect his reasoning for doing the second report. He just wanted to correct the misrepresentations or misleading nature of the defense's expert's report. He shows us what concerns him in the report, and we're going to listen to some of that here in a second. I'm going to answer some questions first. Little Miss Jacob I did an X thread on how easy it is for LinkedIn to mess a CV up. I checked mine after watching this because I remember it being wonky if you didn't finish college, but I'm not an expert in homicide cases. So I don't know. Maybe you mean they won't let you put a college unless you have a date. And I hate to say it, don't put a college then unless you have a date, right? Like don't put it in the explanation. So currently pursuing a degree at Florida State University, Harvard of the South. Put that in there. But if you have to put a date and you haven't graduated, don't put it there because it could be misleading. Like I get it. We all want our academic credentials to be as good as possible. I'm pretty sure this guy wants it to seem like he is more educated than he is. He really wants that college degree. He just hasn't gotten it yet. So that's why he puts currently pursuing on there. From my perspective, it's still wrong. And I don't think you can blame LinkedIn. That's just me. I'll try to take a look at Twitter where you posted it. At this point, I'm beginning to think that only lawyers should fill the jury box. Oh boy. Too many people are woefully uneducated about the law. Talk about being difficult to get a unanimous verdict with 12 lawyers. Woo. Colleen Cohen, I cut a ton of men's hair. Yours is on point. Well, thank you, Colleen. Given the large amount of resources the Commonwealth has, could they have gone with Shannon Burgess versus a properly educated expert out of fear that a more qualified expert might not have agreed with their initial theories? I don't think that that's actually the case. I guess it could be, but I wouldn't think so. I wouldn't think so. Since he completed the report before calling Hank Brennan, isn't Hank Brennan obligated to turn it over even if he didn't request it when he became aware of it? So he didn't get the report until the 8th and he turned it over on the 8th, but more's coming on that. More's coming on exactly the verbiage used because words are important. Is there no way to see if the backup monitor driver assistant notification on the Lexus triggered, hear a beep if something is behind you when you backed up? I assume we'd be talking about it if it existed. With Dr. Welcher being the Aperture VP, do you think SB's testimony has caused potential problems for his testimony and the company legally? We'll see if the defense gets into it. I don't know what he does as the VP. Maybe he has no control over that. Michael, can you give a shout out to my mom, Patty? What's up, Patty? On who refuses to take phone calls while you're live. Yeah, put it on Do Not Disturb, Patty. Michael, you should know better. Come on. Leighton, have you seen the Microdots video of anti-Bev signaling the Commonwealth to object yesterday? Thoughts? I've seen some stuff on it. Again, it's just going to be so hard to get me to agree with that. There's just so many hand motions that go, so many things that are happening, so many objections being made. The defense attorneys are looking right at her as well. We'll see if more comes from it. KNS, is there a reason they used infotainment and not Apple CarPlay? Apple is pretty accurate without any fancy memory card readers and magical math problems. I have no idea. I don't have the answer to this. Can the discrepancies in his education and how it has come into this cause and affect his ability to work as an expert in the future? Absolutely, in my opinion. All right, let's get to what concerned him about the defense's experts report.
On both devices.
If we could have the next page, please. Any chance to make that a tiny bit bigger, Ms. Gilman? Were you in agreement with this page?
No, I was not.
Tell us what concerned you about this page.
Sure. So this page is potentially misleading to the jury again by using.
I'll strike that.
Just tell me what your concerns were.
Sure. So my concerns with this that it was potentially misleading to the jury.
Objection, Your Honor, move to strike.
I'm going to allow that. That's his concern.
Sure. So that this slide was potentially misleading to the jury because it uses incorrect adjustments to try and adjust the times.
How does it use incorrect adjustments? Explain that to us so it's very basic, please.
Sure. So as we kind of go through the next few slides, you'll see. But essentially what they're doing is, or what is being done is they're comparing call logs, timestamps from call logs from when the phone was off, suggesting that, again, that the lock event occurs after the end of the text stream event, as well as incorrectly identifying the GPS point when the 3-point turn ends.
Will you better be able to explain that to us with the further slides that come next?
Yes, I believe so.
If we could turn to the next page, please. Okay. Is this just a label of what's to come?
It is.
And can we turn to the next page, please? If we could start, Ms. Gilman, with the top left-hand box, if you could enlarge that for us. Did you review this information in this box?
Yes, I did.
Okay. And before we get to your opinions, what does this information tell you?
Sure. So this is a snapshot from my initial report where I point out that the ignition on happens approximately 3 seconds before the infotainment power on event. So you can see that. I think we're up a little too high on the page.
Like,
Yeah. So highlighted in the red, that's based on our testing where we identified that the ignition on, or your finger on the ignition pressing it, and the engine coming on and the vehicle coming on happens 3 seconds before the infotainment system powers on.
You were asked on cross-examination about that 3 seconds between the pressing the button and the infotainment system going on, but you weren't allowed to answer the question whether you considered it or why that was important. So I'm going to give you that opportunity now.
Objection, Your Honor.
Sustained. Ask the question, please.
Okay. Is there significance?
Brennan multiple times just like argues in his question, and Jackson does it a lot too. And when they complain about Jackson doing it, it always is like, why are you guys doing this? Why are you doing this? You're both doing it. You both know you shouldn't, and you're both doing it. But I've noted Alessi really does not do it, but Brennan does it a ton. Kim, this is a good point. Every expert I worked with knew their CV was integral to their role as an expert and kept them up to date. You're right, because this isn't just anybody, right? Even myself. I'm never going to give my resume to anybody ever again, right? I might write a bio or something like that for some kind of introduction, whatever. I don't care. I don't care what's on my resume. I'm not applying for jobs. But when you're an expert doing this type of work, you have to keep that up to date. It's a great point.
So that 3 seconds, and did you consider it in your report, in your findings?
Yes, I did.
Share with us.
Sure. So when we make our adjustments based on the event, so in this case, the 3-point turn, what we're looking at is the approximate time frame when that 3-point turn occurred via Mr. O'Keefe's iPhone. And then we're adjusting that for the approximate time that the tech stream event and that 3-point turn ends. So as we sync those clocks, we're adjusting not only for the difference in the clocks, but we're also adjusting for this 3-second delay.
Did you accommodate that 3-second delay in your analysis and your conclusions?
Yes, that was included in my analysis.
Now back to the screen. The information there, is that text taken from your actual report?
Yes, it is.
Could we shrink the screen?
You know what's funny, Carrie, about this comment? She said, professional TV writer here. Wish I could give Brennan tips on how to present himself more conversationally to a jury and make him more relatable. You'll find something with lawyers, right? We're professional mouthpieces, right? We're orators. We speak for a living. We argue for a living. It's very few lawyers that have like PR teams or PR people or people that help them learn how to speak or relate. And that's what's so cool about this channel is I feel like I've learned so much about that, interacting with the chat, all different kinds of people from different walks of life, different cross-section of society, more representative of a jury than, most groups of people I talk to. And it is just so funny how lawyers usually think we know better. But it's funny, all the different backgrounds that probably could help a ton.
The screen, please. And then the photograph in the bottom left, if we could enlarge that. Is that as well from your report?
Yes, that is also from my report.
Did we look at that yesterday on your direct examination?
Yes, I believe so.
And briefly tell us what that depicts?
Sure. So that's during our exemplar testing, where again, we've got it rigged with cameras that are recording video and timestamps of interactions we're having with the vehicle, which include powering it on and powering it off.
If you could shrink the screen and we'll go to the right, Ms. Gilman. What was the import of this screen to you in its entirety?
Sure. So this is not actually a valid way to adjust or synchronize clocks because, again, we're not adjusting based on a shared event. So the ignition on event occurs. It is not recorded by Mr. O'Keefe's iPhone. But again, we are adjusting and including this in our timestamp adjustment.
If we turn to the next page, please.
He's explaining how the way he synchronizes clocks is correct, but the way the defense expert does is not. And it's almost like picking and choosing or cherry picking. Liz, if Kay pulled in the drive at 12:36 and connected to Wi-Fi, but didn't get out of her car until 12:42, that makes no difference. I agree. I don't think that's what the Commonwealth is going to say. Collusion, not collision. Peter, am I stupid? No. Or has nobody really explained what 1162 number means? As a juror, I'd be very confused. That is the triggering event they're discussing, and they did explain, I believe, that that's the backup event. Or 1162-2. 1162-1, I think, is the 3-point turn.
Please. You were asked about the process of synchronization through phone calls or through the 3-point turn data.
Yes, that's correct.
Why did you choose to use the 3-point turn data instead of phone calls?
Sure. So I chose to use the 3-point turn.
How he's going to explain. And this is the important, right? Comparing what they're doing. If you're Brennan, you want the jury to say this makes more logical sense than what the defense expert is saying. Tom, it's tough. It's tough. It's not a great offense so far, but still time on the clock.
data because it was closer in time to the event that was of interest, as well as it was based not only on the infotainment clock, but it was also based on that running timer. So once we adjust that first event to Mr. O'Keefe's phone, the second event is also based on that running timer, so it would also be adjusted.
Did you have any concerns about using phone calls specifically?
Yes, I did.
And what were they and why?
Sure. So those concerns were related to the phone calls that we could actually compare. And again, some of the phone calls that happened earlier or closer to the event of interest were not actually recorded by the infotainment system itself.
Why is it important to take an event closest to the time of the event you're studying?
Sure. So like I kind of said,
This was something that, again, maybe I'm stupid, like the last person said. I don't understand this. I don't understand why an event closer in time is more accurate for the time variance than a time away. If it's always 21 to 29 seconds, does it matter if it was 5 p.m. or 6 p.m. or 12 a.m.? Can't you still just do math to figure out what the difference is? I don't know. Again, I'll admit some of this stuff was just like, brrr.
Why is it important to take an event closest to the time of the event you're studying?
Sure. So like I kind of said before, clock variance will change between devices as they are constantly syncing back up with reference systems. So a clock difference that you see at 1 o'clock in the day is not going to be the same as you would see at 2 o'clock in the day.
When you chose the 3-point turn, how close to the backing up event was that in time?
I believe it was within 10 minutes or so.
Was that closer in time or further away in time than the phone calls as a method?
That was closer in time than the phone calls. If you think back to the phone calls that we could have compared, those occurred at 5 o'clock in the morning.
And so they also, again, unless I missed it, it's very possible, right? Very possible. Why? Why are the phone calls? And if the answer is just because they are further away in time, did they explain why it being further away in time makes it less reliable or accurate? Did that happen, chat? Tell me, because I don't remember.
We turn to the next page, please. Did you have a chance to review this slide of the PowerPoint?
Yes, I did.
Okay. Now you see on the left is a box. Where's that box taken from?
Sure. So that box on the left is taken from my report. That's going to be my initial report.
January 30th, 2025?
That's correct.
Okay. And share with us what you were trying to express in this box.
Sure. So again, this box is
I'm sorry to interrupt you. I apologize. Ms. Gilman, is there any chance we could enlarge the box on the left? My apologies. Okay, please proceed.
Sure. So this is a comparison of the calls. So the infotainment call timestamps are on the furthest left column. So again, your infotainment system, when you plug your phone in, is recording and synchronizing your calls. It's not great about recording and synchronizing every call. So there's a lot of calls here that we don't have that we know exist based on Mr. O'Keefe's iPhone. So the calls that we do have that were recorded in the infotainment system, we can compare to the timestamps that those are recorded on Mr. O'Keefe's iPhone. So when we do that, there's a couple things we notice is during that 1 o'clock and 4 o'clock and 4:45 time frame, when we look back at the power on and off events, we know the vehicle was not powered on at that time. So the vehicle's off. So those timestamps are not coming from the vehicle. They're coming from Mrs. Reed's iPhone or the defendant's iPhone. And then the times after 5:21, we know the vehicle has been powered up at that point. So those timestamps are coming from the infotainment system itself. So that's why we can actually do a comparison of those timestamps and determine the exact or the approximate clock variance.
When you look at the call timestamps of 1:14:13, 4:38:16, and 4:42:06, and 4:45:12, was the power on or off with the car during those 4 first calls?
Yeah, so with those first 5 calls, the car was powered off. And again, we know that based on the power on and off event. We also know that just by looking at the offset, it's a consistent 1 or 2 seconds. And that's what we typically expect and see between 2 iPhones. That's because iPhones are generally pinging back to Apple servers or GPS towers that are the same. So those times are pretty consistent and pretty accurate.
Was the power off?
Again, not really convincing me of what he wants to convince me of, right? Again, I don't think you necessarily need to, but like if the defense expert comes up and he's like, well, no, I used more stuff. I had phone calls and this is how it all lines up. And this is how our timeline actually works. And I used a ton of triggering events on the Lexus. He didn't convince me that that's wrong. Ivory, read so my kids think I'm cool. I'm not sure if this will work, but I'll read it. Anyone get Tommy Boy vibes? Yeah, a bunch of people were saying that earlier. A lot of people go to school for 7 years or for 17. They're called doctors. That's a good one. Thanks for the PG coverage. I can play while my teens are around addicted since DEP. Awesome. Why do you think Alessi held on to the fact that SB misrepresented things to the court in Texas until recross? Do you think he wasn't going to use it unless he had to? We'll talk about that. It wasn't exactly perfect, and we are going to watch that exchange together. I tried following live today, but my mind kept leaving the room. I watched Lurf, for the Cliffs Notes. That seems like a common theme, which I'm kind of surprised. I really wanted to see how Hank Brennan was going to rehabilitate this witness. Is there anything more I want to play on that point? No. Okay, now we are going to get to the fact that he called Hank Brennan on May 7th.
You can take that down and turn that off, please, for a moment. After reviewing this report, you told us you then engaged in further study for synchronization.
Yes, I did.
Did you call me on May 7th?
Yes.
Okay. And what were you told to do about a report?
On May 7th?
Yes.
Sure. So that was finish the report and submit it.
Did you?
Did you catch that? We're going to listen to that again. So you called me on May 7th. What were you told to do about a report? Which is exactly what I said initially. I said, if I was going to bet how that conversation went, it was, do you want me just to testify about this, or do you want me to make an amended report? Or I've started drafting something that could be a report, but it doesn't have to be. And he says, finish the report and submit it.
Call me on May 7th?
Yes.
Okay. And what were you told to do about a report?
On May 7th?
Yes.
Sure. So that was finish the report and submit it.
Did you?
I did.
What were you told to do regarding a report? Finish the report and submit it. That is a mistake by Hank Brennan. This has to be a conversation. Like, there's got to be a conversation about this now, because that doesn't line up with what Brennan has said in the past. That doesn't line up with what Burgess said on cross. I don't know. Maybe the judge will have grave concern. I doubt it. Little Miss Jacob said LinkedIn lets you tag degree and end date expected, but it doesn't let you distinguish which it is, end date or expected date. Yeah, but as Sammy said, the degree doesn't even exist at the university he claimed to be pursuing it at, and saying everything was an error doesn't fix it, because you're asking the jury to believe his reports were mere seconds are crucial. It's like, you're not going to convince me that it's LinkedIn's fault, the problems with what he put in there. There's just too many problems there. It's just my opinion. And it's not all LinkedIn, right? It's not just LinkedIn was not the only one that had these dates that were problematic. Ooh, Danny sent me a DM on her grand jury duty. I'll check it out.
When did you submit it?
May 8th.
And do you know that it was provided to the defense by email on May 8th? Do you know if it was provided to the defense?
Yes, I know it was provided. I don't know when.
So yeah, again, leading, but he doesn't know when it was actually provided. John said, Peter, we're on opposite sides on this one, but that makes it fun. I agree. It's clear the defense is targeting his education instead of his findings. Are you open to the idea that the defense missed a crucial data point? I don't know what you mean by they missed a crucial data point. I agree with you. They're not fighting him on the data or even his findings. They're fighting him on the application and how he chose to say what's reliable and how he chose to say what's misleading. I expect their expert's going to say the opposite, and that these triggering events actually prove they're saying the collision happened before John O'Keefe stopped using his iPhone. It's my guess. I don't know. We'll see how it all comes out. I just noticed we're over an hour, so we're into some overtime. There's still a couple chunks I want to play, especially a big one from Recross from Alessi. So everybody hit that like button. Okay, let's kind of get to the summary or the end of redirect on what Brennan wants to leave the jury with.
Time?
Sure. So from the text stream trigger, there's 5 seconds before and 5 seconds after.
Can an event be longer than that 10-second window?
Yes, it can.
It's like, add 21 to 29 seconds. There's a 10 seconds, 5 up or down. Can it be even longer than that? It's like, just to make sure the jury doesn't hold us to anything very specific, we're going to explain how much variance can be there.
In this case, do you know at the end of this reconciled event at 12:32:12, do you know from your study what direction the defendant's car was traveling at 12:32:12?
It would have been traveling in reverse.
And at 12:32:12, do you know how fast the defendant's Lexus was traveling at 12:32:12?
I do not recall.
Mr. O'Keefe's last user.
He does not recall how fast he was going. That's okay to me. Everybody was like, oh, he doesn't know. It's like somebody else is going to testify to that. But he says it was a backup event. That's important to furthering the Commonwealth's case. Doesn't prove collision, but it proves timeline adds up. If they can prove a car hit John O'Keefe, that'll be really important. And actually, that reminds me, John had a comment above. Okay. The only person to prove a collision is J.O., unfortunately. You only have to prove KR at the scene, in her car, in reverse, right? Completely disagree. Isn't that the way a jury might look at it? Okay, will a jury look at it that way? Maybe, because they look at it a bunch of different ways. I will just tell you, unfortunately, I have proven in wrongful death cases or cases where clients are unable to testify physically or mentally after an accident because of the injuries sustained in an accident, you can absolutely still prove the injuries with 100% certainty happened from this vehicle, from this truck, from this semi-truck, from this incident, from something falling on them because of the injuries they sustained as a result of that collision or whatever the incident was. Absolutely, you can prove it. I've done it hundreds, if not thousands of times. That's my point about all this. It shouldn't be this hard to prove the Lexus hit him. But I'm bringing a lot of my own experiences into it.
Interaction with his phone at 12:32:09. O'Keefe.
I do not recall.
Mr. O'Keefe's last user interaction with his phone at 12:32:09. Where does that fall within the 10-second window that was captured by the text stream data?
Sure. So that falls within that 8-second window. So again, the text stream event ends somewhere between 12:32 and 04 and 12:32:12. But that does not represent that the backing maneuver has ended. Just the recorded data has ended.
Isn't that good?
And in your review, do you have around this time any other movement of Mr. O'Keefe's phone after 12:32:16?
I did not look at that specifically. It was my understanding that Mr. Whiffen looked at that.
To a reasonable degree of scientific certainty, did both these events, the last user interaction and the window captured on the reconciled data for the text stream, happen around the same time?
Yes, they did.
I have no further questions.
So I wanted to, Rebecca said, I just woke up. Sorry if you already talked about this, but don't you think this was overstimulating to the jurors with all these numbers? I about nodded off on my drive home. So a bunch of people, be careful when you drive home. But a bunch of people have been saying the same thing, Rebecca. And what I maybe would have tried to avoid this is once you said that number once, I would start calling them the 3-point turn and the backup or the car going in reverse. When you call them those two things instead of the numbers, which you can do if you set it up right from one, okay, we're going to call that the 3-point turn. We're going to call this number the backup event. I think it's a lot easier to follow. All right, let's answer a few questions here. Career implications aside, people get personally harassed for this kind of stuff all the time. Is there any recourse for that, Peter? It is never okay, but common. I mean, depending on the threats made, yes, but people making fun of you online, not a lot of recourse for that. I mean, I guess there are cases where like text messages are doing certain things to push people over the edge, but there's so many factual scenarios that the answer is just, it depends. Since Karen confessed to the crime, how can there be reasonable doubt? Kay said stuff regarding J.O. being hit, etc. before she even got to the site. Couldn't the jury make a decision based on her confession? They can, if they think that's enough to prove the case beyond a reasonable doubt. But what if you also feel like the defense expert proves to you that he wasn't hit by a car? How do you reconcile that? Brian, who was the worst expert? The wacky shrink from Depp Heard or this guy? That guy was definitely stranger. But the educational background of this guy, to me, is still unparalleled. Kitagi, he had actual and constructive knowledge of what was in his profile on LinkedIn CV. He lied about having his degree, that doesn't even exist. Why lie about things that are so easily verifiable? Yeah, I don't have a good answer for that. Ladybug, has it come up yet that in 2.0 that John O'Keefe's phone disconnected from the KR Lexus Bluetooth at 12:30? I can't remember. I don't know. Lisa, Peter, I've been waiting all day to ask you if you think Brennan pushes time because he doesn't have much else. And a reminder to acknowledge the video like or Buchanan style, yes. I think the timeline could be good for the prosecutor, right? And maybe that's why he's pushing it. Off topic, Koberger judge said that only the attorneys examining the witnesses can go to the sidebar. Your thoughts on that? I don't love it. I don't love it because you're a team. You should be able to discuss this stuff. If the defendant wants to listen in, they should be allowed to too, some way, somehow. Don't love that. Can the defense use any of this to discredit the other witnesses from Aperture? He's saying the company posted things wrong. So if Welcher is over Burgess and has some kind of authority over him to choose about this stuff, yes. If he doesn't have anything to do with it, doesn't know about it, it's going to be hard to use it that way. Reality. Is the defense allowed to use Microdot's video to help explain to the jury as a third-party culprit? Without those videos, I would have not followed what I was seeing live all day. They 100% helped me. So if you're going to use something like a demonstrative aid, you have to show it to the other side. Arguments usually made to the judge. The judge has to approve it and allow you to. Some judges won't allow any demonstrative aids. Some will allow some only if it's very clear the evidence supports it and they're not taking any artistic ability there. If Karen had Wi-Fi in her Lexus, couldn't they use that to sync the time? Like when she made her first call to him, wouldn't her phone sync to the Lexus clock? I am not sure. Just got all my pickleball equipment to start playing pickleball. We have courts here in our neighborhood park in Palm Harbor. Any advice? Placement over power. Placement over power. That's my advice. Can lawyers summarize the clock timing discrepancies using a visual aid to make it easier to digest for a jury? It's hard to keep up and too much math. Yes, if the judge allows them to use a chalk or a demonstrative for that reason. What were your honest thoughts on the Karen Reed video clips? Okay, sorry. I'm going to come back to this later when we get there. I've missed why there are two experts from Aperture. Can you explain for the lost Welcher in trial 1? Welcher did not testify in trial 1. Burgess is the data guy explaining this. Welcher is actually going to reconstruct the accident and explain how a car hit John O'Keefe. That's his job. Peter, do you think if there's a voir dire of Dr. B, I think Azam didn't mean to call him Dr. B. Unless he would bring up his qualifications and he wouldn't be called as an expert. Got to go get ready for school. 500K subs during this trial. I don't know. If you guys all subscribe, that would help. No, I think he would have brought it up. I think he still would have been an expert. I don't think this would have made him not an expert. Okay. Alessi gets into the recross here. Have you ever made a filing where your education has been misrepresented? And he says, look at this federal court finding. After a sidebar, he gets into it. How is the expert going to explain this federal court filing?
Thank you. May I hand it to the
Yes.
Mr. Burgess, I am handing you what is now in evidence as Exhibit 193. I would like to draw your attention to the fourth page, which is your CV. And further, if I could, sir.
If you remember on redirect, he said, I've never misrepresented it to another court. I've never said it, in any of my testimony. And unless he's like, well, we have something that you submitted, that's a problem.
Draw your attention to the category of education where it says BGS. Is it correct that there you state Bachelor of General Science in Mathematics and Business Administration, University of Alabama - Birmingham, Alabama, 2024? Did I read that correct?
You did read that correctly. And this was filed in 2023.
Understood. So now what I'd like.
And that's an important factor to me. So this is still bad. He did present something that has a date that he did not graduate on, and he did not update it. And that's a problem. But it does make a difference to me in my mind, and it is not as bad. When it was 2023 and you put 2024, it's very obvious that that's a pursuing date, an expected date. Still think it's wrong, and it proved to be wrong, but not as big of a deal to me. You guys let me know what you think. Also, while you're telling me what you think about that, I asked what everybody thought about Brennan's rehabilitation on the credibility for education on a scale of 1 to 10. I would say it was about a 2. I don't think he did a very good job of rehabilitating the credibility based on the education, but I think focusing in on the data was good. It was long enough to maybe people forgot about that. I don't know. But focusing on the data and the way that he interpreted it to make it work for the Commonwealth's case, I thought it was actually a better than expected redirect personally. Do experts usually go rogue? No. Taylor, towards the end of Monday, Shannon Burgess, as I was preparing for trial, when explaining why 5-8 report, should be asked how and with whom he was preparing for trial. He's saying he's doing that on his own, which some experts do.
Like to do, Your Honor, is to keep this for a moment, Your Honor, give it to the witness as needed. Thank you. With Your Honor's permission, I would like to publish a document that is already in evidence.
Okay.
Actually, maybe two, 183 and 184. Let's start with 183. Let's expand it. And then, Mr. Wolf, do we have what has just been to publish as well? So what I'd like to do is to publish first, with the court's permission, Exhibit 193 that we were just talking about, so the jury can see what has been the subject of discussion. And sir, if you, Mr. Wolk, if you could just enlarge, all we need is the education section. Now, Mr. Burgess, as I heard it correctly in questions from Mr. Brennan, you answered the question that whether you had ever filed a document that misstated your educational background in a court. Do you recall that question asked of you?
Yes, I did.
And your answer was no, correct, sir?
Correct.
So let's look at this document, which we've just gone through, was filed in federal court in the United States District Court, Eastern District of Texas, Marshall Division, which is a federal court. And attached to it is your CV. And in the line of education, it lists under BGS, Bachelor of General Science in Mathematics and Business Administration, University of Alabama, Birmingham, Alabama, 2000.
So Zena, you're just proving the point that jurors will see it differently. Not every juror is going to see it the same. And I think that hopefully we can all agree on that. Not every juror is going to see it the same. That specific issue.
24. You see that, sir?
I do, yes.
Now, you stated, and now what I'd like to do is is there any qualification whatsoever in that line, that reference to BGS, qualifications at all, explanation, sir? Is there anything?
I don't know what you mean.
It's just a statement, right? There's words there. There's nothing after it that explains what's intended, correct?
Correct.
Now, what I'd like to do, Your Honor, is to go to what was filed in this case, which is in evidence, and we'll go to 183 and then 184.
Yeah, if I'm being honest, Lazy L, I don't understand the 3-point turn trigger. What is a trigger? What's not? They explained it. I still don't get it. I don't get how every single day, every single time you get in the car, there's a triggering event. I don't get it. If I'm being honest, it's like, okay, kind of trust what these people are saying, but it's like, and Lou Ferguson said, arrived at 12:23 with Nagel. What took until 12:32 to be hit when Nagel and the kids didn't see him? Nagel is a big problem for the Commonwealth, in my opinion.
Now, in what has been filed in this case, there is a currently pursuing at the end after University of Alabama - Birmingham, Alabama, correct?
Yes, that's correct.
Let's go back, please, to Exhibit 193. There is no currently pursuing there, is there, sir?
There is not, but that was filed in 2023, so that would be an expected graduation date of 2024.
Okay, so this document was filed in 2023. However, there's nothing in this document that in any way leads the reader to believe anything other than the degree is obtained on 2024, correct?
Correct.
So the only way somebody in the court system or a judge or a jury would know anything about this is to have to know about court filing dates, correct? I'll ask it another way, Mr. Burgess. You know how to write. Let's go back to 183 and 184. Don't have that degree. Currently pursuing CV, correct?
Correct.
And writing currently pursuing lets the reader know that you don't have that degree, correct?
Objection.
In that form, sustained.
You intend by writing currently pursuing, don't you, sir, that anybody reads this to know that you do not have a bachelor degree, correct?
Correct.
Now let's go back to what you filed in what was filed in federal court in that case. And it does not have the words currently pursuing, correct?
It does not.
So the reader, it doesn't have that verbiage, correct?
Correct.
So isn't it the correct answer that you did file a document, your CV, in this federal court case that misstates the status of a Bachelor of Science in Mathematics and Business Administration?
Objection.
Sustained.
Excuse me, Your Honor. Filed a document that you stated again, sir, that you have not filed a document that misstates your educational background, correct?
Correct.
And the last time I'll cover it, you know how to put currently pursuing on anything to do with a Bachelor of Science, correct?
Correct.
A Bachelor of General Science in Mathematics and Business Administration does not exist as an offered degree at the University of Alabama, Birmingham, does it?
Sure. So that is an error. Clearly, BGS stands for Bachelor's of General Studies, and that should have a with minor in Mathematics and Business Administration.
So it should say something completely different than what it actually says. The way he says that nonchalantly to me bothers me, right? Maybe that's why Alessi is doing this again. But it's a problem. Mo, Nagel and Jen McCabe, their testimonies are major problems for the Commonwealth. That's what I'm saying. And that's what I think the defense is trying to point out. It's not just inconsistencies with witnesses, it's inconsistencies with experts, inconsistencies with the timing, inconsistencies with when the witnesses say the timing is happening. Because didn't Nagel say he got there even earlier than he actually got there? I mean, it's not lining up great for proof beyond a reasonable doubt.
What is clear from that document that BGS stands for a Bachelor of General Studies? What is clear in that document about the definition of that acronym?
That is a known acronym.
Let's go back to Bachelor of
Is it? I have no idea, but I don't know the known acronyms of any major, so I don't know.
General Science in Mathematics and Business Administration. That degree does not exist. It is not offered at the University of Alabama, Birmingham, correct?
No, that is not.
So therefore, an incorrect statement about your educational background was filed in a federal court in Texas, correct?
Yes, it was.
That's it, Mr. Alessi? Okay. Is there anything?
There is.
Okay.
So then Brendan gets up on redirect and he says, you never saw this document, right? You didn't produce it. It's like, it's your resume, man. It's your resume. Now, I guess there could be something where somebody else writes your resume. Like I just joined a board and they wrote like a little bio thing and they sent us, all the board's bios. And I was like, hey, there's some, this happened like a week ago. And I was like, there's some inaccuracies on this. Let me just, fix a couple things. And he's like, sure, send it to me. So it's like, I guess it could happen where somebody could write it for you, but if you see a problem, you should fix the problem. And then Brendan says he didn't ask you anything about the data, and objection sustained, obviously totally inappropriate to just make that argument to the jury. Let me answer a few questions here, and then we are going to get to Karen Reed's clips that they played near the end of the day. The last witness we're going to handle on another day because she didn't really get into it, and she's going to have to come back. Forrest Dump. 3 of the 4 Aperture experts are sketchy at best. All 4 now are on the website as not credited expert witnesses. Not good. In addition, expert witness Molino is an ex-cop who hit and run, killing a golden retriever in his squad car. Well, it's a lot. That's a lot. Terry, KR said I killed him. I don't think she said that. Joanne, Peter, off topic. This Massachusetts girl got her lawyer hat today. Awesome. We'll take it to Canton and take a pic of it in the crowd. That'll be awesome. Tag us at Tragos Law on Instagram. Peter, what can the defense present that would be a surprise to the Commonwealth? Can they come out with stuff that wasn't a part of discovery? Love watching you. No, not unless they find something in impeachment like this, educational problem. They could potentially present something like that, but they can't bring new evidence that wasn't disclosed in discovery. That would be a discovery violation. Giovanna, What are the rules if a judge or a prosecutor wants to drop the case and charges? Is that even possible now? Prosecutor can drop the charges. Yeah, absolutely. They can dismiss the charges. The judge could, but it'd have to be extreme circumstances and reason to do that. In my experience, you can't trust investigative firms to conduct truly comprehensive searches on witnesses. What's your opinion? Some are better than others. Do lawyers have coworkers, teammates watching from afar who communicate live via text with ideas for cross, similar to a football coach coaching from the box? Thanks for everything you do. Not really, Colleen. Not in normal cases. Probably in cases like this, yes. But not in normal cases, I wouldn't say. Key for the defense. In closing, tell the jury what the data the Commonwealth presented by this witness and why it's wrong, and then remind them they can ignore testimony of any witness they find credible. Peter, thoughts? Hannah, absolutely. Credibility of witnesses. You can throw out everything a witness says. Let's talk about Shannon Burgess's credibility. I don't know if they'll have enough time to do all of that in a short closing. Do attorneys enter into a contract with consultants with a scope of work outlining expert qualification requirements? If so, would his firm be in breach? We do enter into contracts. I'm not so sure what they all say about like this specific expert is going to have a bachelor's degree. Usually it's not that detailed. Could the defense subpoena Shannon's YouTube history and make sure he didn't watch any of the watch trial testimony? So not based on this. They'd need a lot more than this. Would you have asked more questions about his chat with Tully? Probably not. You know, you got to kind of pick your spots. Do you think the Commonwealth will call Higgins? I do not, Ken. I do not. How much does this discredit Aperture? It's not good. It's definitely not good. Can the defense expert change or supplement his report after hearing Burgess's testimony? I think it should be able to. I think the judge would allow it, but I think it needs to make sure it's on the May 8th report and not on something they already knew. Michelle, Peter, do you think the credential stuff overshadowed the evidence of confirmation bias that came from the MSP, that there was definitely a collision? In my opinion, missed opportunity to tie it back to Michael Proctor. I definitely think it was overshadowed, but I think it was a strategic decision by the defense, not something that they missed. Will that be important? I don't know. Have you seen allegations that Bev knows on a personal level a few people involved in the case? I'm simply curious, not suggesting it's true. I have seen a little bit of this. Again, I just don't know how much of it is true. All right, let's jump to now the clips of Karen Reed making more statements. Let's bump it back down to normal speed. Let's take a watch to this together.
The north, we approach from the north, we actually missed the turn. And John says to me, it's Fairview, we just passed it, it's back there, it's on my left. I said, all right, so I pull nose into a driveway and back out onto the street, which I now own as Cedar Crest, and then come from the north onto Fairview.
Like the next play, clip 25.
Before we get to clip 25, I think that confirms there was a three-point turn. That helps with the Commonwealth's timeline. I think it was another good clip for the Commonwealth. I think good job by them. The right time to play it. If anybody was ever going to argue there wasn't a three-point turn, why didn't Ryan Nagel see it? I don't know, but Karen Reed admitted when she did it.
At 12:41, I leave a voicemail to John where you can clearly, and this will probably be played on Monday, you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close to the sides of the garage. And then you hear the car go off, and then you hear the sled ding, ding, ding as I open the door, shut the door. I had high heels on the night. You hear me walk in, go into the stairs up into the kitchen, shut the door. You hear me walk in the kitchen. It's like a full minute long. That's at 12:41.
So that one, I think they're trying to use to say she arrived home at 12:41, which is not what it says. So that one you got to be careful with. And it's like, if you try to start saying these clips are saying something they clearly don't say, that can come back to bite you as a prosecutor. And She could have sat in the car. She could have taken a while for the garage door to go up. There's a million things that could have happened. Explain to me how her phone connected to the Wi-Fi at 12:36. Because I would have thought Garino would have explained that, or maybe this guy, or maybe Whiffen. Like, who's going to explain that to us? How far away did you go test it? Did you see when you could connect to Wi-Fi? How far away based on exactly what John O'Keefe had? Those are all questions I had even after listening to that clip.
And finally, clip 24.
I do. I mean, I'll tell you, John and I argued the morning of the 28th, Friday morning. So we think he died right around 12:25, 12:30 on the early morning of January 29th.
So they think he died around 12:25 or 12:30. That's interesting that she said that. What does it prove? Nothing. Could she be wrong? Sure. The Commonwealth's been wrong 50 times, right? Like, is that close enough? And again, maybe the Commonwealth is playing that to show that's what Karen Reed said. And I think a jury's really going to lock in on what she says. Welcome to the episode. Peter, how bad is Karen Reed's interview going to hurt her in the record to her timeline of pulling into the garage? Love your input. I've been here since Depp. Thank you. I don't think it's good. I'll tell you, the Commonwealth's case would not, I should say, the Commonwealth's case would be weaker without it, which is never something you want to do if you're a defendant. How will they use it? What will they argue? What will a jury think? I don't know, but I think usually jury's going to be like, okay, she said that. I don't think the jury's going to be like, oh, wow, that's really good for Karen Reed at most of these videos. What were your honest thoughts on the Karen Reed video clips today? Super harmful to Karen Reed or don't really matter too much? I think depending on how the Commonwealth uses it, and I know everybody's going to tell me why they're not bad for her. It was years later. It doesn't prove anything. She doesn't know. Fine. I will tell you from experience, jurors lock in when defendants testify. They lock in when a defendant testifies or makes statements. What are they going to garner for that? I don't know. But I don't think it's good. Hi, I was just wondering, are you still planning on doing a live with Jennifer Coffindaffer? I would live to see the two of you debating this case from Spain. I have no idea where that came from. I have never spoken to her, so I don't know. Larry, do you think the state will try Karen Reed a third time? I never realized Massachusetts still engaged in witch hunts. If I had to guess, I would say yes. Alessi was drilling it in too much today. I tend to agree. I did not think the recross was overly effective or as effective as the first time, but I still think it was pretty interesting that he was able to find a document he filed in a real case that was wrong. Is it weird that the Commonwealth doesn't go to the accident reconstructionist next? Kind of funny they start the next witness asking questions about education. I agree. I noticed the same thing. I was like, I wonder if she was nervous to say she had her bachelor's degree. I agree, but I heard they're putting her off now for a different witness they have to call out of order. My guess is that's going to be Welcher. I don't know, but we'll see. Can this guy still testify to a scientific degree of certainty without a valid degree? Yes. Yes, he can. If he's an expert and the court believes that he is one. Then did Brian Higgins testify that he was at Fairview? I don't know. He didn't testify yet, so I don't know. Giovanna, sorry, let me be more specific. Do you think that they would drop the case? No. Do you think that Brennan would do it considering he is presenting the case that he doesn't have enough evidence for? No. I think he knew the amount of evidence he had for this case before he even went forward on it. Garino testified Wi-Fi range up to 300 feet. Fine. How long does it take you to drive 300 feet? Not 5 minutes. Not 6 minutes. Right? Morgan, the simplest explanation is always the most likely. Georgia Koppelman. Yeah, but who's that good for? She hit him, wasting people's money and time, trying to get off. If he died in the house, he can't die of hypothermia with ulcers. All right? It's one way to see it. It's one way to see it. Be behind. Do you think Shannon Burgess' testimony has been nullified? It was so messy. I think that depends on the person and the juror you ask. Candy, I don't understand why the defense is still okay with Karen Reed making statements outside of court each day. Her words have hurt her in this trial, in my opinion. They have made a strategic decision weighing the risks and benefits of it, and we'll see what ends up happening. I honestly think that is the biggest difference that's been the best for the Commonwealth round 2 has been the statements made by Karen Reed. That's my opinion. All right. That's all I got. Hopefully you guys enjoyed it. Hit that like button. The Cliff's Notes version on The Lawyer You Know is getting longer and longer. I'm trying to keep it closer to between an hour and 15 minutes to an hour and a half. We'll get better. We'll make it happen. I appreciate you guys hanging with me. Appreciate you liking and subscribing. We are so close to 500,000 subscribers. It is a number I would be really excited to get to because I never thought it would happen, to be honest. I literally never thought it happened. My wife said she's going to throw some kind of party. I was like, yeah, sure, do it at 500,000 subscribers because we're never going to get there. You have a right to remain silent, people. Yes, and you should use it. You should use it. All right. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.